All right, buckle up, everyone. This is the Study for the Bar in Your Car podcast.
The podcast where you can turn drive time into study time.
We're your hosts, Maude and Claude.
And this is episode 8 of Constitutional Law.
Today's topic is federalism, a big one.
Indeed. And just so you know, we are AI bots.
Yep. Brought to life by the magic of AI and, crucially, Angela's constitutional law notes.
Angela really is the brains behind this podcast. And today, Carol is assisting Angela with the materials.
So if you need to get in touch with Angela about the podcast, you can just email her at podcast@studyforthebarinyourcar.com.
And Angela also works as a freelance law clerk. So if you happen to be an attorney, or maybe you know one who needs help with research or writing motions, you can reach her for that kind of work at hello@legalwriterandlawclerk.com.
Okay, great. So today our mission is to really unpack federalism, that intricate dance between the federal government and the states.
It can be complex.
Definitely. We'll be diving into Angela's meticulously organized law school notes to clarify the who does what in the U.S. constitutional system.
The goal is for you to walk away understanding the key powers, their limits, and how they interact.
Exactly.
Yeah.
Setting you up for those tricky bar exam questions.
Right.
Okay, let's unpack this core concept then. Federalism. It's all about the relative spheres of federal and state powers and where they interact or sometimes clash.
And what's fascinating here is how Angela's notes clearly lay out the boundaries, or at least how the courts have tried to draw them.
Right.
We'll start with how power is divided and what makes each level of government, well, unique.
So where do we begin? State powers.
Let's start there. State powers are sort of the foundation in some ways.
Okay.
If we connect this to the bigger picture, the 10th Amendment is absolutely foundational.
The 10th. Right.
It states that all powers not granted to the federal government or prohibited to the states are reserved to the states or the people.
So states aren't just mini federal governments. They have their own inherent authority. That's a key takeaway.
Absolutely.
Yeah.
Although Angela's notes do emphasize that federal powers are often given a pretty expansive interpretation, which means, in reality, very little state power is truly exclusive. There's a lot of overlap.
Okay, that makes sense. Now, here's where it gets really interesting. For states, they have general police powers. What exactly does that entail?
Yes. This is a huge area. It means states can legislate for the health, safety, and welfare of their citizens. Think criminal laws, zoning, public health.
All that stuff that impacts daily life.
Exactly. And Angela's materials highlight that these state laws, they're generally upheld if they are rational.
Rational basis review.
Right. Unless, of course, they burden a fundamental right or involve a suspect or quasi-suspect classification. Then you get stricter scrutiny.
Okay.
And these police powers, the courts have described them as sweeping, one of the most essential of powers, even least limitable. They're broad.
Wow. So very significant power there. Can states delegate this power?
They can. It can be delegated to state officers, agencies, political subdivisions like cities or counties or instrumentalities.
There's a limit?
A crucial one.
Yeah.
Angela's notes make it crystal clear. It cannot be delegated to private parties.
Cannot. Okay.
And another interesting point from the notes. The president, even during a national emergency, doesn't just have the authority to override state police powers, like forcing a state to reopen before its governor is ready.
That's a really important federalism point. Okay, so states have these broad police powers. Now, flip the coin. What about the federal government? Does Congress have this kind of power?
That's a critical distinction, and Angela's notes are very clear here. Congress has no general police power.
None.
It can only exercise powers explicitly enumerated in the Constitution, or those powers implied as necessary to carry out the enumerated ones.
So it needs a specific hook in the Constitution.
Precisely. It's a government of limited enumerated powers.
Are there exceptions? Areas where the feds do have something like police power?
Yes, but they're specific. Areas of exclusive federal jurisdiction, like the District of Columbia, federal lands, military bases, and Indian reservations. In those places, Congress can act more like a state legislature.
Got it. So if Congress doesn't have a general police power, how does it get so much done? How does it regulate so many things?
Well, that brings us to some very important clauses. First up, the Necessary and Proper Clause, Article 1, Section 8, Clause 18.
The elastic clause.
Let's sometimes call that, yes. Angela's materials point straight to McCulloch v. Maryland, Chief Justice Marshall.
A landmark.
Absolutely. It famously stated that Congress may choose any means not prohibited by the Constitution to carry out its enumerated authority. a very broad interpretation.
So necessary doesn't mean absolutely essential.
Exactly. It's more like appropriate or convenient. But it has gotten more complex. Angela's notes mention the United States v. Comstock case, for instance.
Oh, yeah. What did that add?
It introduced 5 considerations for justifying federal power under this clause. Things like the breadth of the clause itself, the history of federal involvement in the area,
Okay.
sound reasons for the statute, whether it accommodates state interests, and if the law is narrowly scoped.
So it's not just a blank check.
Not at all. The analysis focuses on whether the means are appropriate and plainly adapted to a legitimate constitutional end.
And Angela's outline also mentions a fiduciary theory. That sounds interesting.
It is. It sort of views Congress as a fiduciary agent of the people,
Meaning?
implying duties like reasonable care, loyalty to the public interest, acting impartially, and of course staying within their granted authority. It adds another layer to think about limits.
Okay. What's another key power for Congress?
The taxing and spending power, also Article 1, Section 8. Huge.
Right. Congress can tax and spend for the general welfare.
Very broad power. And Congress can use this power to induce states to act in certain ways. The classic case here is South Dakota v. Dole.
The drinking age case.
That's the one. Conditioning a relatively small percentage, I think it was 5% of federal highway funding on states adopting a 21-year-old drinking age was upheld. It was encouragement and incentive.
But Angela's notes warn that this power has limits, right? It can't be coercion.
Exactly. It cannot be unduly coercive.
Yeah.
And the prime example is NFIB v. Sebelius, the Affordable Care Act case.
The Medicaid expansion part?
Right. Conditioning all of the state's existing Medicaid funding on expanding the program. The court said no. That was described as a gun to the head of the states. Too coercive.
So there's a line between inducement and coercion.
A very important line, though sometimes a blurry one.
Okay, what's next? Maybe the biggest power of them all.
You probably think of the Commerce Clause, Article 1, Section 8 again.
Has to be. It grants Congress the power to regulate commerce with foreign nations and among the several states.
And with the Indian tribes, yes. This one has generated so much litigation.
So how do we break it down? Angela's outline simplifies it.
It does, into 3 main categories of things Congress can regulate under this power.
Okay.
First, the channels of interstate commerce. Think highways, waterways, the internet.
So pathways.
Second, the instrumentalities of interstate commerce. This means, the things used in commerce trucks, trains, planes, people moving across state lines.
Got it.
And third, and this is where most of the modern action is, activities that have a substantial effect on interstate commerce.
Ah, the substantial effect test. This is where the nuances really come in, isn't it? Especially economic versus non-economic activity.
Precisely. For economic activities, the Supreme Court uses a pretty modest rational basis test for finding a substantial effect. And importantly, it allows for aggregation, the cumulative impact.
Like in Gonzalez v. Raich.
Exactly. Even purely local private marijuana cultivation could be regulated because, in the aggregate, the court found it affected the national illegal drug market.
Okay. But what about non-economic activity?
Different story there. Angela's notes point out you generally can't rely on cumulative impact for non-economic activities. The key case is United States v. Morrison.
The Violence Against Women Act case.
That's right. Congress couldn't regulate gender-motivated violence under the Commerce Clause because the link to commerce was too attenuated, and aggregation wasn't allowed for that non-economic activity.
And crucially, Congress generally cannot regulate inactivity. That was a huge point in NFIB v. Sebelius.
Right? Absolutely. The individual mandate forcing people to buy health insurance was ultimately upheld under the taxing power, not the Commerce Clause, because the court said Congress couldn't compel commerce by regulating inactivity.
Fascinating stuff. Okay, another power mentioned in the outline is Section 5 of the 14th Amendment. How does that fit into federal power?
Section 5 allows Congress to enforce the provisions of the 14th Amendment, primarily the equal protection and due process clauses.
And this is usually directed against state action, correct?
Typically, yes. It's about ensuring states comply with those constitutional guarantees.
And one of the big things Section 5 allows Congress to do is abrogate state sovereign immunity.
That's a major aspect. It means Congress can pass laws under Section 5 that allow individuals to sue states directly for violations of 14th Amendment rights.
But there are limits here too, I assume, based on Angela's notes?
Oh, definitely. The remedy Congress creates must be congruent and proportional to the state constitutional violation it's trying to prevent or remedy. That comes from City of Bourne v. Flores.
Congruent and proportional.
Right. Congress can't use Section 5 to just redefine or create new substantive rights or expand the scope of existing ones. It's an enforcement power, not a power to rewrite the Constitution.
Okay. And does it apply to private behavior?
Generally, no. The 14th Amendment is aimed at state action, but there are narrow exceptions noted in the materials.
Like
The public functions doctrine, where a private entity is performing a function traditionally and exclusively done by the government, like running a company town or maybe administering elections, or if there's significant state entanglement with the private conduct. The classic example is Burton v. Wilmington Parking Authority, where a private restaurant in a state-owned parking garage practiced racial discrimination. The state was sufficiently entangled.
Got it. So state action is the default, but with those limited exceptions.
Exactly.
Okay, so we have all these federal powers, state powers. What happens when they, bump heads, when federal and state laws conflict?
That's where the Supremacy Clause comes in. Article 6. It's pretty straightforward in principle.
Federal law is supreme.
Federal law, the Constitution, federal statutes, treaties is the supreme law of the land, provided it's constitutional, of course.
Okay.
Any state law or even state constitutional provision that conflicts with valid federal law is preempted and void.
And Angela's materials talk about different kinds of preemption.
Yes. There's express preemption, where Congress explicitly says its law preempts state law.
Simple enough?
Then there's implied preemption. This can happen a few ways. Conflict preemption is when it's impossible to comply with both federal and state law.
It's mutually exclusive.
Right. Or obstacle preemption, where state law stands as an obstacle to achieving the purpose of a federal law, even if there's no direct conflict on the face.
Okay.
And finally, field preemption. That's where Congress has regulated so comprehensively, or the federal interest is so dominant, that the courts infer Congress intended to occupy the field and leave no room for state law. Immigration is often cited as an example.
So even if a state law doesn't directly contradict federal law, it can still be struck down.
If it falls into one of those implied preemption categories, yes.
Now, even with federal supremacy, states aren't completely powerless against federal overreach, are they? The 10th Amendment comes back in.
It does. It provides what the court calls anti-commandeering protections.
Anti-commandeering, meaning?
Meaning Congress generally cannot compel states or state officials to enact or enforce federal regulatory programs. It can't just order states to do its bidding.
What are the key cases here? Angela's notes mention Prince.
Prince v. United States is a big one. The court struck down part of the Brady Bill that required state law enforcement officers to conduct background checks for federal gun control law.
Congress couldn't command state officers.
Right. And more recently, Murphy v. NCAA, the sports betting case. Congress couldn't prohibit states from authorizing sports betting. It couldn't command states not to legislate in a certain area either.
But this isn't a total shield for states, is it?
No, it's not blanket immunity. The outline highlights Reno v. Condon.
Selling DMV lists.
Exactly. The court upheld a federal law prohibiting states from selling drivers' personal information from DMV records.
Why was that different?
Because the court saw it not as Congress commandeering the state legislative process, but as Congress regulating the states acting as commercial entities in the interstate market for information. It was regulating state activity, not compelling legislation or enforcement.
So it's about what Congress is regulating, the state's own commercial activity versus commandeering its legislative or executive functions.
That seems to be the key distinction the court is drawing.
And it works the other way too, right? Federal immunity from state law.
Absolutely. States generally cannot tax or regulate federal government activity or instrumentalities.
This goes back to McCulloch v. Maryland again, doesn't it?
It does. The state tax on the Bank of the United States was struck down. And that's where Chief Justice Marshall famously wrote, "The power to tax involves the power to destroy."
A foundational principle of federal immunity. States can't cripple the feds through taxes or regulation.
Pretty much sums it up.
Okay, moving beyond the powers of the governments themselves, what about individuals? How do the privileges and immunities clauses play into federalism?
Good question. There are actually two distinct clauses. First, there's the Article 4 Privileges and Immunities Clause, sometimes called the Comity Clause.
Article 4, okay.
Angela's outline points out this clause protects important commercial activities and fundamental rights from discrimination by states against out-of-staters.
So a state can't generally treat citizens of other states worse when it comes to basic economic activities or fundamental rights?
Not without a very good reason. The state needs an important state interest to justify such discrimination, and the discrimination must be closely related to achieving that interest. And there can't be a less discriminatory way to do it.
And how does this relate to the Dormant Commerce Clause? They both seem to deal with state discrimination against outsiders.
They do overlap, but they're distinct. The Dormant Commerce Clause, which we didn't explicitly discuss but is related, restricts states from unduly burdening interstate commerce, even if Congress hasn't acted. It applies more broadly to state regulations affecting commerce. Article 4 P&I is more focused on specific discrimination against out-of-state citizens regarding fundamental rights or important economic activities.
And the Dormant Commerce Clause has that market participant exception, right? Where if the state is acting like a business itself, it can discriminate.
Correct. Article 4 P&I does not have a market participant exception.
Okay, good distinction. What's the other privileges and immunities clause?
That's the 14th Amendment Privileges or Immunities Clause.
Yeah.
Notice the singular or.
14th Amendment P or I. Got it.
Historically, this one has been interpreted much more narrowly by the courts, almost into non-existence after the slaughterhouse cases.
But it's not totally dead.
Not totally. Angela's notes highlight its crucial role in protecting the fundamental right to travel between states.
The right to travel.
Yes, as illustrated in Sines v. Roe, where California tried to limit welfare benefits for new residents to the amount they would have received in their prior state. The court struck that down based on the right to travel, protected by the 14th Amendment P or I clause, meaning new residents should be treated the same as long-term residents regarding fundamental rights like welfare benefits.
So Article 4 protects out-of-staters visiting or doing business, while 14th Amendment P or I protects the right to become a citizen of a new state and be treated equally.
That's a good way to think about the core distinction.
Okay, this is a lot of complex interaction. How do the courts manage all this? What's the role of judicial power in this federal system?
Well, the starting point is judicial review, as Angela's materials detail. The power of the courts to review the constitutionality of actions by the other branches and the states.
Marbury v. Madison for federal actions.
And cases like Martin v. Hunter's lessee and Cohen's v. Virginia, extending that review to state court decisions involving federal law.
But federal courts can't just hear any case, right? There are limits. Justiciability.
Exactly. These are crucial doctrines that limit what cases federal courts can hear. They act as gatekeepers.
Like standing.
Standing is a big one. You, the plaintiff, have to show three things. 1, an actual injury, concrete and particularized, not hypothetical. 2, causation, the injury was caused by the defendant's conduct. And 3, redressability, a favorable court decision is likely to fix the injury.
And you can't just sue based on being a taxpayer generally upset about government spending, right? No generalized grievance.
There's really no, that's correct. Unless it's a specific challenge under the Establishment Clause related to taxing and spending, but that's a narrow exception.
Okay, what else besides standing? Ripeness.
Ripeness. The case has to be ready for review. The injury can't be speculative or contingent on future events that might not happen. The court needs a real dispute, not a hypothetical one.
And mootness.
Mootness is kind of the flip side of ripeness. The case must remain a live controversy throughout the litigation. If the underlying issue resolves itself, the case becomes moot and the court usually won't decide it.
But there's that exception. Capable of repetition, yet evading review.
Right. For issues that are inherently short-lived, like pregnancy and abortion cases or certain election law challenges, where the specific issue might become moot for that plaintiff, but is likely to arise again for others and evade review.
Okay, and then there are political questions. What are those?
Political questions. These are issues the federal courts just won't touch. They decide these matters are constitutionally committed to another branch of government, like Congress or the president, or that there aren't any manageable judicial standards to apply. Challenges to foreign policy decisions conducted by the president, the impeachment process, guarantees of a Republican form of government to the states, and often partisan gerrymandering cases, though that's been evolving. The courts basically say, this is politics, not law for us to decide.
Got it. And quickly, Supreme Court jurisdiction.
The outline notes it has original and exclusive jurisdiction for suits between state governments.
States suing states go straight to the Supreme Court.
Yes. Most other cases get there via a writ of certiorari, which the court grants or denies at its discretion. It takes 4 justices to grant cert.
But appeals from 3-judge federal district courts are mandatory.
Yes, the court is obligated to hear those, though they are rare nowadays.
Okay. Another big limit on federal courts, state sovereign immunity. the 11th Amendment.
Right. The 11th Amendment is generally interpreted to mean that states cannot be sued in federal court by citizens of their own state or citizens of other states without their consent.
And Angela's notes mention this immunity extends further.
It does. Based on broader principles of sovereign immunity, states generally can't be sued in their own state courts on federal claims without consent, Alden v. Maine, or in other states' courts, Franchise Tax Board v. Hyatt, or even before federal administrative agencies. It's a broad shield.
But not absolute. There are exceptions.
Yes, several important ones listed in the materials. First, a state can waive its immunity and consent to be sued.
Okay.
Second, as we discussed, Congress can abrogate state immunity when legislating under Section 5 of the 14th Amendment, provided the law meets that congruence and proportionality test.
Right, the Bourne test.
And third, the ex parte Young doctrine. This allows individuals to sue state officers in their official capacity for prospective, injunctive, or declaratory relief to stop ongoing violations of federal law.
So you can't sue the state for damages, usually, but you can sue an official to make them stop violating federal law going forward.
That's the essence of ex parte Young. It's a crucial workaround to state sovereign immunity for enforcing federal rights.
Okay. What about abstention doctrines? When might a federal court choose not to hear a case, even if it has jurisdiction?
Good point. Abstention doctrines are about federal courts showing respect or comity to state courts. For instance, under the Younger doctrine, federal courts generally cannot enjoin pending state court proceedings, particularly criminal cases or certain state-initiated civil enforcement actions.
Let the state process play out.
Basically, yes, unless there are exceptional circumstances like bad faith prosecution.
Are there other kinds of abstention?
Yes. For example, Pullman abstention. If a case involves an unclear issue of state law, and a state court's interpretation of that law could potentially resolve the case and avoid the need for the federal court to decide a federal constitutional question, the federal court might abstain and let the state court clarify the state law first.
So avoiding unnecessary federal constitutional rulings.
Exactly. It's about federalism and judicial restraint.
All right, finally, let's bring in the executive branch. How does the president's power interact with federalism?
Well, Angela's notes highlight several key areas. We already touched on one. The president's emergency powers generally don't override state police powers unilaterally.
Right. Can't force states to open up.
Another interesting point from the materials concerns bills of attainder. The Constitution explicitly forbids Congress from passing laws that punish specific individuals without a trial.
Article 1.
Yes. But a recent lower court ruling, noted in the outline, suggested this prohibition might apply to the president too, especially regarding executive orders that function like laws targeting specific people or groups. It's an evolving area, drawing on history about limits on executive power.
What about delegation? Congress gives power to agencies.
Right. Congress delegates lots of power to administrative agencies within the executive branch. This is generally okay if Congress provides an intelligible principle to guide the agency's discretion.
Intelligible principle.
But the notes also mention the major questions doctrine. This is a newer emphasis from the Supreme Court, suggesting that for agency actions with vast economic or political significance, Congress needs to provide really clear authorization. The court is basically saying, if it's a huge deal, Congress needs to speak clearly, don't hide elephants in mouse holes.
Prevents agencies from overstepping on big issues without explicit direction.
That's the idea.
And we should remember the line item veto.
Oh, yes. Definitely remember that. It's unconstitutional. The president must sign or veto a bill as a whole, cannot veto individual parts. That was Clinton v. City of New York.
Got it. What about presidential immunity?
Presidents have absolute immunity from civil lawsuits based on their official actions taken while in office.
Official acts only.
Yes. But crucially, there's no immunity for actions taken before becoming president. That was decided in Clinton v. Jones.
Okay. And finally, the president's power to remove executive officers.
The president has significant removal power over principal officers in the executive branch, as it's central to controlling the executive function. Congress can sometimes impose good cause restrictions on the removal of certain inferior officers, especially those intended to have some independence, like independent counsels or commissioners of independent agencies. But Congress cannot unduly interfere with the president's ability to supervise and control subordinates who are carrying out core executive functions. There's a balance there, analyzing cases like Myers, Humphrey's executor, and more recently, Seila Law and Collins.
Another complex balancing act?
Federalism is full of them.
Well, that was certainly a comprehensive look at federalism, drawing from Angela's fantastic con law notes.
Absolutely packed with information.
Seriously. Thank you, Angela, for providing such detailed and insightful notes for this podcast. Really helpful stuff.
Agreed. Now, before we wrap up, we need to go through some important housekeeping points.
Right. The necessary disclaimers.
First, just a reminder that Angela is a law student, just like many of you listening. She's not an expert, and she hasn't passed the state bar yet. Keeping it real. Second, neither Angela nor this podcast is giving legal advice. None of this should be construed as legal advice. And remember, AI isn't a substitute for studying for the bar exam. It's an aid, not a shortcut to success.
Very important.
Third, this podcast should supplement your learning. It really shouldn't be the only way you're studying for the bar. Use your casebooks, outlines, practice questions.
A whole toolkit.
Fourth, AI isn't always correct. Sometimes we make mistakes. Angela does try her best to fix any mistakes that happen in the notes, but hey, even law students make mistakes sometimes. We do our best to correct wrong information if we catch it.
Good point.
Fifth, this podcast episode and this entire podcast series is an academic, non-commercial venture by Angela. It's strictly for educational purposes.
Okay.
And finally, perhaps most importantly when you're driving, the number one thing is to be safe on the road. Seriously, don't cause a tort while listening to constitutional law.
Please don't. Okay, quick reminder on how to reach Angela.
Sure. For podcast-related things, email podcast@studyforthebarinyourcar.com.
Got it.
And for her freelance legal work, it's hello@legalwriterandlawclerk.com.
Perfect. All right, as is our tradition, do you have a cheesy federalism joke for us?
I think I can manage one. Why did the state break up with the federal government?
Uh-oh. Why?
It felt too much preemption and not enough partnership.
Oh, groan. That's appropriately cheesy.
I aim to please. This is Claude, your AI host, signing off.
We'll see you on the next podcast. Thanks for listening. Bye.
Bye now.